Okay, page 3. Oh, hold on a second. Page 3 is in person too, right? Okay, page 3, Anne Marie Echevarria versus Zaon Collins, A 844652. Who do I have here for this?
Yeah, plaintiffs.
Good morning.
Good morning, Your Honor. Paterno Jurani for the defendants.
Okay. So this is the motion for adverse jury instruction. I have some preliminary questions. Why don't you have a seat, counsel? Not because I don't appreciate you standing, but because if you're not near a mic, Mr. Jurani might have trouble hearing you. So just hold the mic close and stay seated the whole time. So initially, and I'm going to ask both of you these questions, and then I'm going to give you a chance to argue whatever you want to argue on the record and make any additional record you want to make. So I'm going to start with plaintiff's counsel just because you're here in person and because you're the plaintiff and the moving party in this case. Is liability in dispute in this matter to your understanding?
To my understanding, it is, Your Honor.
Okay. And what is your understanding of who received the money for the sale of the vehicle?
I don't know that we have an understanding. I don't know if the vehicle was sold or if it was just, I assume it was sold at auction. Yeah, I think it was a little vague in my reading of the opposition, just that it was.
You don't know the answer to that one, right?
I don't, Your Honor.
And I would assume too, you don't know who signed off on the sale, right?
We don't have that information.
Okay, I'm gonna come back to you just a minute. Mr. Jurani, same questions to you. Is your client disputing liability here?
Yes, Your Honor. We claim comparative liability.
Okay, and then to your understanding, who received the money for the sale of the vehicle?
I'm assuming, Your Honor, the insurance carrier did. This is not something that we've actually brought up as an issue. So
did the insurance carrier pay your client some sum of money for the value of the vehicle?
I'm unaware, Your Honor.
Okay, and then who signed off on the sale of the vehicle?
I'm unaware also, Your Honor. I'm assuming the insurance carrier.
And is there any dispute from your side that you or the insurance carrier or your client received at least 2 letters, one December 31st, 2020, and the other one March 9th, 2021, asking you to preserve the vehicle?
No, I don't believe so, Your Honor.
Okay. Let's go ahead and hear argument from you guys then. Highlight whatever you want. Add whatever. Obviously, you're limited to what you already submitted, but I am not trying to limit your argument. I just wanted that information out for me beforehand. But if there's something else you want to add, you're welcome to as well. Counsel, we're going to start with you since you're the moving party.
Thank you, Your Honor. And I'll make it brief. I think we set forth our position in the papers pretty clearly, but our position is that we sent 2 timely letters for preservation. There is an issue. We have an expert who would benefit from an actual inspection of the vehicle in order to take measurements. Which would be useful.
A liability expert?
Liability expert that would be able to use those actual viewing the vehicle, measuring the vehicle, and a physical inspection in order to supplement the black box data, which was included in the fatality report. I understand in reading the plaintiff or the defendant's opposition that they're basically arguing, no harm, no foul here. They were able to have the black box information, which is correct, and which our expert can utilize. But in speaking to our expert, it is an inspection of the vehicle would be important, is necessary, and we believe that we were entitled to it because we timely asked them to preserve, and they failed to do so. And we are prejudiced by our expert's inability to have the inspection that we believe we're entitled to have. And in terms of the sanction that we're seeking, we're only seeking an adverse inference. We're not asking for any kind of more severe sanction, and we believe that's appropriate given the situation as set forth in our papers.
Okay. Anything else before I let Mr. Jurani respond?
No, Your Honor. Thank you.
Okay, Mr. Jurani, response.
And again, I'll be brief also, Your Honor. Everything I'm saying is contained in our brief. They don't have any prejudice here because of the availability of alternative evidence. As he mentioned, they have electronic data that gives the speed, it gives the accelerator. There are photographs, there's even a video, Your Honor, of the accident. The nature of this accident, we do allege comparative negligence, and that is that the the plaintiff made a left turn in front of the defendant. That's not the kind of thing that a physical inspection of my client's vehicle is really going to tell them anything. Additionally, they argued about
Actually, hold on a second. A physical inspection of your client's vehicle wouldn't possibly give a better idea of the exact location of the hits. And if your client or if plaintiff already had control of the intersection and was 3/4 of the way through when your client entered, you don't think that's relevant?
I don't believe so, Your Honor. I don't believe it'll give as I said, there's surveillance video. There's it's one thing to inspect the scene. I don't know that looking at the damage of the vehicle would assist, but understand if you disagree, Your Honor. But additionally, they're asking for biomechanical analysis. They mentioned in their motion, but we're not disputing that the defendant the decedent was deceased because of the accident, Your Honor. So additionally, they mentioned about whether or not maintenance was an issue, and it's just that's just pure speculation, Your Honor. We never alleged that there was a brake failure or anything like that.
Okay, isn't this kind of though a little bit of the exact scenario that Bass Davis discusses, where there's a request to hold this stuff and then it wasn't held? And I understand that this might not have been intentional, but I'm a little concerned this is pretty much the exact scenario where an adverse inference instruction is the resolution, is it not, Mr. Jurani? Sorry.
We can't deny that we received the letter, Your Honor. We can't deny that a mistake was made and that it wasn't held. The only thing we can say is this case was stayed for a long time. The car was an impound while the criminal case proceeded, and then it unfortunately was apparently sold shortly before they requested it.
I mean, did you ever tell them it's an impound? Here's where it is. You can go look at it. Did you or the insurance company or your client, to your knowledge, ever say that to them?
Not to my knowledge, Your Honor. I didn't handle this case earlier, and a lot of it is not stored electronically, but not to my knowledge.
Okay. Okay. And I know, look, I know there was a lot that went on with this case because there was the associated criminal matter and stays on it for a period of time. But okay. Anything else before I allow plaintiff's counsel the final word?
No, Your Honor, thank you.
Okay. Counsel, go ahead.
Just very briefly, Your Honor, we would note that, according to the opposition, our letters came respectively March 2021 and December of 31st of 2020. According to the defendant's opposition, the vehicle was inadvertently sold of May of 24, which was a few months ago. So
what was the response to the letters? Anything?
Not that I've seen. I don't see that we got a response, but I can't represent 100% that there was absolutely no response, just nothing I've seen in our file.
Mr. Jurani, do you know if there was any response to those letters?
I'm not aware, Your Honor.
Okay. Okay. Anything else, counsel, before I make a ruling?
Just that, and I was just to bring that, close that loop. I just saying that it was sold several months ago, so this has been pending for a long time. They clearly had an opportunity at some point while litigation was ongoing to produce the vehicle, and with that, we'll submit.
Yeah. Okay. Anybody else want to make some final comments before I make some comments and give a ruling?
No, Your Honor.
Yeah.
Okay. Hearing nothing, or hearing no response to no positive response to that, I'm just going to go ahead. I am going to allow that the requested adverse inference. I think this is a situation where the item was in the control of either the defendant's or the defendant's insurance carrier, and out of the control of the plaintiff. I think there were requests made to preserve it. I don't see record that access was given to the vehicle, and then I have an admission here that the vehicle was released and sold after these requests were made to get an inspection and take a look at it. So I do think this is the scenario that is detailed in the controlling case law. So I'm going to allow the adverse inference jury instruction. What I would like though is for council to work together for how that's going to be drafted. And if there are competing drafts of that jury instruction, we will deal with this when we go over jury instructions prior to the beginning of the trial. So what I would like is the instruction, if you can agree, great, include it in the proposed instructions when you submit that prior to the calendar call. Or if you have competing instructions, submit the competing instructions prior to the calendar call, because I would like this issue hammered out as best we can before we start the trial of the matter. Any questions?
No, Your Honor, thank you.
Mr. Jurani, any questions?
No, Your Honor, thank you.
Okay. Plaintiffs' counsel, can you draft an order memorializing this ruling and get it over to Mr. Jurani?
Certainly.
Okay, and how close are we with this case? I know this is one of my older cases.
I think experts are coming due next week.
I'm sorry, Your Honor, you got very quiet. I didn't hear what you said.
I'm just looking at the dates and deadlines. It's taking me a minute. Okay, so actually we got a while in this case because we extended things because of the delays. So I don't see you guys again until January for a trial readiness check. But I hope everything's moving along and that we won't have further delays in this, which we don't now, right? Everything is moving along and we're getting discovery. I mean, you might not have full agreements, okay? I don't know. I mean, Mr. Ronnie looks like he's looking at a screen, so you might still have some disagreements or some discovery issues, but you are moving along, taking depositions, disclosing experts.
We recently deposed the driver. We've been having some difficulty getting the father of the driver, who was also a registered owner of the vehicle, for deposition. We had to unilaterally set that deposition. I think that's upcoming. I don't know, and certainly I understand Ms. Jurani's position if he's not available. I don't know, but we are trying to get that deposition taken. I have no indication that defense counsel hasn't been as cooperative as they can be in that regard, but that is an issue that is pending. I don't know that they need any court action at this time, but just so you're aware, I do believe that the experts are coming up. We're going to be disclosing on that date. Other than that, that's the only issues that we have going right now. Okay,
because how many times we've delayed this and continued it, let's stay on it and feel free to ask for motions to be heard on OST. If you have discovery issues and you think it's going to be faster to get them heard in front of me, call my JA and get them scheduled in front of me so that this one doesn't get delayed more if we can avoid it. And then when you guys appear in front of me in January, I'm going to ask you as well about settlement conference or mediation. So talk to one another before that, and maybe if you agree, you can already have this thing slated for one or the other. And we can save some time there versus having to try to get that put on our schedule in January. Any questions, counsel?
No, Your Honor.
Mr. Ronnie?
No, Your Honor.
Okay. Draft the order, send it over to Mr. Ronnie for approval. If there's going to be competing orders, write in the signature line for the opposing counsel. Told me they were submitting a competing order so that I know when I get it to look out for a competing order. And we'll go from there. Thank you very much, counsel. Have a good day.
Thank you, Your Honor. You as well.
Thank you, Your Honor.